I am pleased to welcome my colleagues Kevin Pomfret and Rob Van Arnam, the co-chairs of the firm's Data Protection and Cybersecurity practice. They will be presenting on recent developments in that space. Kevin approaches these issues from a corporate law angle, as he's a partner in our corporate section. And Rob approaches these issues from a litigation perspective, as he is also the chair of the firm's intellectual property section. Rob and Kevin advise on businesses and privacy and data protection laws. They also advise clients on compliance, including establishing privacy policies and data security plans. They represent clients in data breach matters and related litigation. Rob, I think you're the one who's going to take it away.
Thanks, Jen, and good morning, everyone. Welcome. Our topic today on data protection and cybersecurity could be its full-day seminar, but we wanted to hit the highlights and some of the new developments in this area. In front of you is the agenda. We're going to talk a little bit about data breach and litigation, then the Virginia new law, the VCDPA, California, the updates from CCPA, and of course CPRA, GDPR update, and then finally we'll take your questions. Before we get into the substance, we have our first polling question to get kind of a lay of the land and your perception of your compliance efforts. So that should be in front of you on your screen. And the question is, what is your level of data protection and compliance in your castle? A, great, we are a fortress. B, good, but we're good, but the drawbridge is a bit rusty and old. C, subpar, everyone tells me things are wonderful, but I keep seeing missing stones in the wall. And D, God help us all. The barbarians are not only at the gate, they're serving mead in the kitchen. So we'll let the answers come in to kind of get a sense of how you feel your company's programs and compliance efforts are. Some variety here as people are responding, but frankly, mostly Bs and maybe some Cs, a few brave souls with Ds. Bottom line, I'll suggest to you that this is an ongoing, difficult exercise. And when I talk to in-house counsel a lot, I found that they may not even know some of the issues they're facing or the information from their business and technical folks that present problems. As you can see from this slide here, it's a persistent challenge. There's all kinds of new issues that companies are dealing with. Increasingly, business is mobile and digital with banking and retail and other things. People are purchasing products and interacting remotely, including our workforce now. The pandemic and maybe for the foreseeable future, we've got people working from home or remote locations, which presents other means and ways for hackers and other people to get into your systems. Your servers in your company may be fine, but what security does your individual worker have in their workplace at home? New technology, both what that introduces and when it obsoletes old versions that you may be still using and aren't supported, that's a way hackers can get in. BYOD in devices, of course, everyone has one now, so making more challenges and ripe for attacks. Similarly, biometrics, as we roll that into the workplace and the things that we're doing. The Internet of Things, where all kinds of devices that from a refrigerator to washing machine to things at work are now data gatherers. Smishing is just phishing on SMS or text, which happens a lot. I'm sure that you have received some probably this week, and your employees get them with links to click, making them vulnerable or you vulnerable to malware. And of course, ransomware, a big one, and a lot of ransomware attacks and ransomware as a service. It's become an actual business now for hackers to work together to engage in ransomware attacks, to hold you hostage and your data, take advantage of that as a money-making proposition. Speaking of ransomware, I think we have our next poll. hopefully this is working. I saw a couple that it's not working for. This is specific to ransomware. So do you believe companies should be allowed to pay ransomware? A, no, never. B, yes, but based on standards or certain defined circumstances. And C, yes, generally, it should be up to the company. And I'll let your answers come in. And obviously, ransomware has exploded, particularly in the last year and a half, in part in response to the pandemic. And just because it's a money-making exercise, 350 million in ransomware payments in 2020, an increase of something like 300% from 2019. And of course, smaller businesses or medium-sized companies are particularly vulnerable because they may not have the resources to have the most robust security in place. All right, I've got most answers, lots of B's and C's, a few A's. And there are a couple people that are having trouble with remember that it's the chat feature using to respond to these participation questions if you're having any trouble. All right, next slide. So ransomware, a persistent problem here. And you know, this question presents the issue. So ransomware has become a multi-million-dollar business. And some people think it should be legislated so that no ransomware can be paid. And the government is looking into this issue, and there are already, of course, laws that restrict payments to terrorist organizations and things of that nature. The problem, of course, is how would you know who the hackers are that are presenting a ransomware problem to you? You simply wouldn't. So I think that's why people ended up in the B and C category. It sort of depends on the circumstances. It does suggest, though, that the more this works, the more it will happen. The government is paying attention, and Biden came out with an executive order on this subject. And it, you know, still sort of work in progress. But the government is trying to initiate public-private partnerships, which I think is a pretty good idea in theory. Sort of we're all in this together to fight this problem. The problem is, you know, the onus then is on the company. Another feature of this is shared or maybe considered compelled disclosure of breaches and information. You know, that's all fine if everybody was on the same page in helping, but of course the spin-off, follow-up regulatory actions or class actions and litigation that follow mean you need to be careful and think about what you're willing to disclose. Another feature is robust and zero trust architecture for cloud storage and secure and protect the supply chain. Great, you know, again, great in theory and really helpful, but do you have the resources to be able to do that? And this is particularly important, and you know, you'll see this more from the government in orders and laws with things like critical infrastructure. We've seen new laws and stricter compliance measures for government contractors, but also I think for software providers and certainly municipalities and critical infrastructure, people that are supporting those efforts are going to have a higher burden. And you know, there's lots of good ways to try to prevent this with system monitoring, password management, multi-factor authentication, things you've probably heard before. And this has to be a routine part of your culture and your business. And it comes down to people. You could have the best policies and encryption in place, but if someone clicks on links repeatedly and introduces malware, you've got a problem. And of course, the breach itself or the ransomware itself attack is not the only problem. It's the follow-up things that happen, including class actions, particularly if there's a theft or an access and acquisition of victim data. There is usually some kind of follow-on litigation. And these are now introduced by plaintiffs' attorneys in various ways. For instance, the Colonial Pipeline attack, there are two forms of class actions now brought by consumers, the people who were individually affected, but also gas station owners who said they lost business because of it. Again, right or wrong, it's just a new avenue of attack of companies who were the victims of an attack and what they have to face. Some good news in this area is the Supreme Court's recent TransUnion versus Ramirez case, which addressed the issue of standing to bring these cases and what harm is required. In that case, the Supreme Court upended a class damage award of $40 million under FCRA, Fair Credit Reporting Act, and really dug in more deeply to the issue of standing and injury. It found that in a 5-4 decision that the majority of the class lacked standing because TransUnion did not disseminate credit reports to third-party businesses during the relevant time period. And generally, and you can see on your screen, what TransUnion is suggesting are elements that will be looked at by courts as to whether they're standing, whether there's a good basis for a motion to dismiss, whether the data was exposed, whether the data set was actually misused. Sort of, is there a threat of harm or is there actual misuse? What type of data was involved? Was it, sensitive? Is it a social security number or something very confidential, or is it PII that could be publicly available? The bad news, as Justice Thomas suggested in dissent, is that while there may be successful Article 3 challenges in federal courts, plaintiffs can simply bring these cases in state courts where the standing requirement may be reduced or minimum. California, Michigan were pointed out as examples. In a Graham case in the Eastern District of Pennsylvania, just this past spring and summer, this was put to the test. Two of the three plaintiffs, their cases were dismissed because they could not show that tie-in to injury. The third plaintiff alleged enough. He alleged that his surgery was delayed and he actually had affected healthcare and insurance from the breach itself. So these cases will continue. These are the elements that courts will be looking to. And again, not just courts and private enforcement and plaintiffs' cases, but the FTC is active in this space. Under the current proposal, the FTC would get $1 billion to set up a new bureau over 10 years to address unfair and deceptive acts or practices relating to data security, privacy, et cetera. Whether they get, all of that or some portion of that, we don't know, but the FTC will certainly be more active in this issue. And of course, data breaches mean preserving privilege. And we go to our next polling question. Next slide, please. All right. And this question is simply, has your company already retained a forensic firm that monitors and or is engaged in testing compliance? And I'll let those answers come in. Only two choices here. All right, I think we've got them all, just about all in. So we can go to the next slide. I would say the majority of the responses were A, yes. You have retained a forensic firm or vendor. Several folks, weren't sure. And of course, there were some, particularly maybe from smaller companies who haven't gotten around to do this yet. That's good news and bad news. So if you've hired a forensic firm already that has done work or is sort of on standby, that's a good thing. You're taking it seriously. But in terms of privilege, there may be some challenges there. In recent court decisions, including one in the EDVA, Capital One, and in the District of Columbia, the Clark Hill case, and a recent one this summer in the Middle District of Pennsylvania, courts have found that these forensic reports and investigation reports subject to or following a breach are not privileged and protected and needed to be disclosed. And that's a difficult proposition because, of course, this should be a company's ability to maintain their investigation with their counsel to protect this information. So this is going to be something to pay attention to. And the problem is, if you have a firm already signed up, the courts have found that that is not in anticipation of litigation or part of privilege with an attorney. And in the Rudders case specifically, the court found in terms of work product, only where there was an identifiable or impending litigation, when that is the primary motivating purpose of creating the document, was their work product. So in these cases, courts found that if you have, almost as a routine part of your business, forensic firms auditing, investigating what's going on with their security and compliance, that may not be a privileged and protected report and document. Similarly, in Rudders, the court found that the report only discussed facts, the investigation, and did not involve opinions and tactics and typical things that you'd see in a maybe privileged document or work product document with communications from counsel. And the court emphasized that the attorney-client privilege does not protect communications of fact merely because there is an issue like a breach. So these are the elements that courts are now looking to. And this suggests that as part of your security and compliance program, that you involve counsel, at least in-house, but also outside counsel at the outset. So, who engaged the forensic firm? If they're already on your payroll and routinely auditing those reports, that information may not be privileged. Again, did they have a pre-existing contract? And literally the courts have looked to the work orders and the statement of works that these firms have been engaged under to see whether it's a protected document. And you can see the rest. What source of the information, who received the resulting report or analysis. This is such a catch-22 because the whole point of compliance is to audit frequently, see if you have a problem, and communicate that. We just talked about the administration's efforts and government suggesting more disclosure, more communication. Well, that's difficult if that's going to blow your privilege and make it discoverable in a separate case. And also what, of course, contemporaneous records there were that created that show the circumstances of the forensic company's work. All right, next slide. All right, so not only is the federal government involved in this, of course, but states, and we're going to get into some specifically. Kevin's going to talk to you about Virginia. Colorado is another state that has new privacy laws. You've probably heard of, from Massachusetts and New York, but also in North Carolina and Pennsylvania. And most states have either active committee or bills in the works that would make more stringent their compliance regime and obligations for companies. Some of these, or many of these, I would say, have been hung up over a few main topics. One is whether it regulates cyber insurance and mandates it. Second, requiring government agencies to implement cybersecurity training, testing, task force. Some supporting programs or incentives for training and education. But there's a lot of disagreement about private rights of action and other things. And so as these, I think there's going to be more bipartisan efforts at the state and federal level here, and there's more agreement that there's a problem. Federal law, again, we're late in the year, so probably not in 2021. But again, a lot of activity here. The Cyber Incident Reporting Act by Senator Gary Peters and Rob Portman was set a 72-hour deadline for critical infrastructure companies to report cyber attacks. And there's a lot of bills and activity We'll see where this ends up. All right, with that, we want to talk about some specific compliance laws and Virginia, and I will let Kevin take it away.
Thanks, Rob. That was a really good sort of overview of where things stand. And as you said at the end, it's really interesting to see how the state and federal law interaction are gonna work together on some of these issues, because there is a significant amount of overlap, and Congress is paying attention to this. But in the meantime, as we're seeing, some states are beginning to move forward, others are certainly considering it. And so there's going to be this tension. And for businesses, it's going to be a real challenge trying to figure out, how to start planning and what they need to be planning for. Next slide, please. So for our poll question, next poll question, we are going to ask, would you prefer a comprehensive federal data protection law or a patchwork of state laws? And answer A, if you'd prefer a comprehensive federal law, or B, if you think each state should be able to decide on its own if and how to protect personal information of its citizens. Looks like we're getting a lot of responses for A, for federal. Some B's coming in. Yeah, someone pointed out with employees in 13 different states, it's really hard to sort of keep track of it all. And that's certainly a challenge that a lot of businesses are facing. But for the reasons that Rob described earlier, federal comprehensive law is proving to be a challenge. An interesting note as we're finishing up these questions is simply that, I don't know if you followed the Facebook whistleblower, if you will, testimony, and her desire to focus less on the content and the data and more on the algorithms. And that's an interest that's more in terms of the Facebook contact and how social media works, but focusing on algorithms rather than data could have some really interesting implications for data protection as well. So that'll be another layer to think about as we move forward. Next slide, please. So earlier this year, to the surprise of many, the Virginia passed the General Assembly, and the governor signed the Virginia Consumer Data Protection Act. It became only the second state to develop a comprehensive data protection law after California. And that's probably one of the few areas in the law where you're going to say that California and Virginia are working together on taking the lead. It was a really big surprise in the data protection and privacy area. It doesn't take effect until January 1, 2023. So there gives companies time to prepare. It is important to note that while it protects residents of Virginia, it's only in their capacity as a consumer, not as an employee. Now, I think that's going to raise some interesting questions down the road, but that is the context by which this act is supposed to take place. And it does protect personal data, but not data that's been de-identified or made pseudonymous. Those are excluded from the definition of personal data. There is no private right of action. As Rob said, that's been a big issue, but there is no private right of action for this, but the Attorney General does have the ability to fine $7,500 for each violation. Now there's a process in place before that fine can be imposed, but it is that capability. Next slide, please. So who's covered by this? That's something that varies. Each state is going to have a little bit different. So for Virginia, it doesn't apply to not-for-profit organizations. It's only for businesses for profit in Virginia that produce products or services that are targeted to Virginia residents, that during a calendar year control or process personal data of at least 100,000 consumers, or control or process personal data of at least 25,000 consumers, and they generate 50% of their revenue from that sale. And we'll talk about some of these definitions in the slides that are coming up. Next slide, please. So in addition to nonprofits that are exempt from the act, also government bodies, authorities, bureaus, commissions, districts, subdivisions are all excluded. Interestingly, and different from the CCPA, it also includes financial institutions that are not subject to Gramm-Leach-Bliley, and entities and business associates that are subject to HIPAA. So if you're subject to those, you're not part of, you don't have to worry about the Virginia Consumer Data Protection Act. And then also institutions of higher education. So universities and such are also exempt from the Act. Next slide, please. So then the next question becomes, what is personal data that's exempt? And there are a number of exemptions, and this is not a complete list, but as similar to CCPA, protected health information under HIPAA is not covered. The Federal Credit Reporting Act, data collected from the Driver's Privacy Act, FERPA, the Farm Credit Act. There's a number of, if data is subject to other protections, other reporting requirements, and other responsibilities, there is likely an exception under the Virginia Consumer Data Protection Act. In addition, as I said, if an individual is acting in an employment context, so if you're collecting emergency contact information, if you're using information to retain and administer benefits, if you're collecting as part of a work process, that data is not subject to the Virginia Consumer Data Protection Act. Next slide, please. So residents of Virginia that are protected by this act, and their data is protected by this act, under section 59(1)(573), they receive a bundle of rights. And these rights, if you've worked with CCPA or GDPR, they're going to be familiar with you. So they have the right to ask a controller, and we can talk about what a controller is in a little bit, but to provide a copy of the information they received, to correct any inaccuracies in their personal data, to delete personal data, and for certain purposes allow opting out of processing. And those, as we'll talk about, includes if the company sells personal data or profiling furtherance of decisions. So residents do have rights that are granted under the Act. Next slide, please. So as I said, most of these reporting obligations or responsibilities belong to the controller, if you're a controller of data. So it's important under the Act to understand what a controller is. And that's defined as an organization that are alone or jointly with others determines the purposes and means of processing personal data. In a very general sense, it can be considered the organization that collects the data. Now, the term controller is something that became familiar to many through the GDPR. It's a little bit of a different definition under CCPA, but the concepts are the same. So if you're familiar with CCPA, you're probably, Virginia is very similar in terms of the roles of a controller. And what is processing? Basically, processing is most anything that you would do with data other than, if you're collecting it. So it'd be storing it, analyzing it, using it, aggregating it with other data sets, modifying the data, anything that you might do if you're doing any sort of analysis on it. It's a pretty broad use of data. So if you're collecting data, you really should consider that you're probably going to be, you'll be processing it in some way, shape, or form. And this also is important to note. It's not just if you do it yourself, but if you're having others process the data for you. So if you could have the next slide, please. So what are your organizations as a controller? You have to limit the collection of personal data to what is adequate and relevant for the particular needs that you have. So what they're trying to prevent there is they don't want you to just be gobbling up all sorts of personal data of your customers or prospects to maybe figure out what you're going to do with it in the future. They want you to have a particular use in mind, and they want you to collect the information that is not relevant to that particular use, and that's referred to often as data minimization. You should only process the data for the reasons that it's been collected. And what that means is, data is very versatile. You can, once it gets into your organization, I like to say that it, like from Jurassic Park, data finds a way, just like life finds a way. From the scene with Jeff Goldblum, it gets in there, and other departments want to start using data for other purposes. Maybe it's collected for marketing, and then all of a sudden someone wants to use it for testing it for some other new product or services. Those type of things are what this section is trying to protect against. You should only collect it for the purposes that you should only use it for the purpose that you've collected. You should put in reasonable data security practices. And as Rob said, there's a trend with it in state laws to require businesses to start implementing data security practices in some jurisdictions, not in the Virginia case, for instance, but it can almost become sort of a safe harbor if you can show that you've adopted certain data protection practices that people have considered reasonable, whether it be from NIST or other organizations. Obviously, not to process personal data in violation of particular law. They want you to, and if you're transferring the data to a processor, to some other organization that's going to store or process the information, you need to have a written agreement in place with some specific provisions included in there, and we can talk about that. And then, as we said, consumers have a right to request copies of information, to request whether you have the information, to opt out information. So you need to have a plan in place to respond to those consumers within 45 days. Now, there's some exceptions to that, but in general, you should think about being able to respond in 45 days. So if you're setting up an inbox, making sure that the inbox is monitored, you know who the question goes to, who's responsible for it. And then you need to establish a process, because a consumer, if you reject a consumer's request, or for instance, you say you don't have information or you're precluded from deleting it for legal reasons, an appeal process needs to be put in place for an individual to challenge that. Next slide, please. So as we said, there's an agreement in place. There needs to be an agreement in place. If you have personal data that's going to be subject to the Virginia Consumer Data Protection Act, you want to have an agreement in place with anyone who's going to be processing your information. At a high level, it should include the nature and purpose of the processing, the type of data that is subject to the processing. So a general description of that, the duration of the processing or the term of the agreement, and sometimes those can be different. And then the rights of obligations of the parties going forward. Next slide, please. And some of these specific provisions are set forth in 59.1.575. These provisions, I think it's important to note, they can be part of the operative agreement itself. It could be an addendum, or it could be a separate agreement. And it really depends on the nature of the personal data that's being processed, how big it is, how important it is, the nature of the contract. So it's not set in stone how you do this, but you need to be able to impose a duty in this agreement on the processor to delete personal data upon termination or completion of the processing, to notify the controller if there's been a data breach, impose as if you as a controller have requirements for data security, which you do through the Act, to make sure that the processor also has sufficient data security measures in place for the appropriate level for the data that's being transferred and the uses it's being transferred for. You also want to apply flow-through provisions, right, to the processor, so that they will be able to respond. If you get a request from an individual, for instance, you want to be able to make sure that you can get your processor to give you the information that you need to respond to a consumer. And so you want to put that in the agreement as well. And then you want to have confidentiality provisions to make sure that your subcontractor or processor has certain, understands the sensitivity associated with the data, has typical protections in place associated with keeping this confidential. So you may be able to rely on your standard confidentiality provisions, or you may need to update your agreements to make sure that it specifically covers personal data. Next slide, please. So as I was saying earlier, data is so versatile, it can be used in a number of ways. And the General Assembly identified certain measures that are so insensitive that they allow consumer specific rights to opt out. And this includes targeting advertising towards a particular individual. If you're planning on selling the personal data to someone else, you collect it and then maybe you sell it to a third party, and there's a whole data ecosystem that's been built up, and there are folks who are responsible for doing that. And then if you're using the data for profiling for decisions that have a legal or similar significant effect on a consumer, and that we'll talk about that definition here in a second. Next question, please. So the sale of personal data, because of the way this ecosystem works, it can be a real challenge to figure out when data is being sold. And the way the General Assembly adopted some language talks about the exchange of personal data for monetary consideration. If you follow CCPA, you know there's been some, or the developments in California, you know there's been some discussion around what constitutes a sale. The law makes it clear that certain aspects don't consider to be a sale. So for instance, if it's through a merger or an acquisition, if you're processing disclosing it to an affiliate, or if you're giving it to someone who's actually processing the data on behalf of providing the product or service that the consumer has paid you for, even though there's consideration going back and forth between you and the processor, that's not considered the sale of personal data for purposes of the Act. And that's an important consideration as well. And then also bankruptcy and some of the other standard provisions, contractual definitions that you'll see, that would not be considered a sale, even if personal data, and increasingly that is part of the assets that's being sold in a bankruptcy, that's not considered a sale of personal data subject to the Act. Next slide, please. So not only are there certain activities that are considered sensitive, but there are certain types of data that are considered particularly sensitive. Data, for instance, that reveals racial or ethnic origin, religious beliefs, mental or physical health diagnosis, things like that. Data that has a genetic or biometric data that's collected from a child under the age of 13, a known child under the age of 13, and then precise geolocation data. So if you're collecting data that is tied to a lat long or some other Wi-Fi or something else, that with a certain degree of granularity, you can identify the location of a device or something that can be tied to an individual, that would be considered sensitive data under the Act. Next slide, please. So if you are collecting sensitive data, you have two requirements that you need to consider. First of all, you may not process that data without the consumer's consent, and that consent needs to be opt-in. And the second is you need to prepare a data processing assessment. So a DPA is a document, it's an internal process that you put into a document where you weigh the benefits and the risks associated with collecting this data. And these benefits are the benefits to the controller, to the consumer, other stakeholders, against the potential risk to the affected consumer. And then once you go through that process, and assuming the benefits outweigh the risks, you need to put safeguards in place to mitigate the significant risks. And if you're familiar with GDPR, you're certainly aware, you're familiar with this process as well in this type of document. But it's going to be increasingly important for the types of sensitive data that we've discussed before. You need to have this two-step approach. Next slide, please. Now, DPA is not only needed if you are using it for collection of sensitive data. You also, if you're selling personal data, you need to go through the DPA process. Or if you're processing personal data for profiling, where it prevents an unforeseeable risk of injury to consumers, or unlawful or disparate impact on consumers, or unreasonable intrusion into their solitude or seclusion. Now, again, all these are high-level terms. The law has not gone into effect, so there's certainly a lot of wiggle room there in terms of what it's going to apply to and what these definitions mean. But it is a concern, particularly if you're doing target advertising, or the closer you're getting to an individual in his or her activities, or his or her family, or his or her home, or you're impacting decisions that are very sensitive to their life or important to their livelihood. You do need to consider whether DPA should be addressed. And this is an area I think that people should be following closely, because it will be areas where people are will be challenging this when they start seeing that personal data is being profiled. They consider personal data is being used to profile them. Next slide, please. So most organizations now have a privacy policy on their website, a privacy notice, and this should this continues that process. But there are certain things that you want to have if you're doing business in Virginia and subject to the Act. So you want to make sure that it's clear about the categories of personal data that you're collecting as a controller, the purpose of processing the data, how consumers may exercise their rights, including a contact point or a website or something like that. What personal data, the categories that are shared with third parties, and the categories of parties, the categories of the types of party that's being shared with. In addition, as I talked about before, there needs to be opt-out for processing of personal data for targeted advertising, and how the procedure for a company or an individual to do that, how to reach out to a company. And again, this isn't new. I think one of the challenges is going to be, and for those of you who responded to the first question, or the poll question that I asked, it'll be interesting to see if you've got you're doing business in a number of states. Do you have specific addendums for each state that applies to particular residents of those states, or do you have sort of a catch-all phrase? And when California was, became the first state to have laws that was impacting, you saw people having sort of a California type CCPA type addendum or statement or notice that was separate. But as you start adding other states, that gets to be a little bit more complex. Next slide, please. So becoming compliant by January 1, 23. Frequently asked, how long does this take? What do we need to do? There's a lot of variables involved. Obviously, it depends on the size of your business, depends on where you're doing business. It depends on how much personal information you collect, how you use it. There's a lot of variables in place. I would say if you're already compliant with GDPR or with CCPA, then you're most of the way there. And you don't necessarily need to get started, today or tomorrow or January of 22. Although it probably would be prudent to understand specifically the difference between those two laws and CDPA, because there are some differences. Some of them are minor. As I said, some of them are definitional, but some of them are more significant in terms of whether it's opt out or opt in. Definitions, for instance, the definition of precise geolocation in Virginia is different than other states. So understanding those differences isn't going to be important, but I don't think it's it's something that's necessary to drop everything in to do. But if you're not subject to those, if you haven't gone through that process, if for whatever reason you're not doing business in Europe and you don't have a big presence in California, but you have a significant presence in Virginia, collecting a lot of personal information and using it in a lot of different ways that maybe you as in-house counsel don't even fully appreciate where it is and what needs to be done. I do think it's important to start that process as early as possible so you can begin to understand what you need to do and how long it's going to take and what the lead time is to get those in place. And some of that's going to be easy. Some of it will be hard, mapping your organization's data supply chain, where the data is coming from, who has access to it, what training's in place, who you share that data with. I mean, sometimes that can be hard, particularly if you've got legacy systems that has data collected from years past, and making sure you collect all that information and understand that so you can start pulling together what's required both internally and externally, and also getting your vendors compliant and your suppliers compliant as well it could be a challenge. So I'd suggest, you may want to start thinking about that. Okay, that's the end of my slide. I'll turn it over to Rob for an update on California.
Thanks, Kevin. That's a great update on Virginia. And as Kevin mentioned, Virginia is a bit of a surprise, adding legislation and requirements. California, not so much of a surprise. And of course, it's been the leader in privacy laws. And the first sort of threshold question, and Kevin sort of suggested this, if you're already compliant or following CCPA, you may not need to do anything as immediately with Virginia. So our first sort of question and poll, next slide. What is the requirement for California? So California privacy laws apply if A, company does business in the state of California, B, company's annual gross revenue is greater than 25 million. C, company receives or shares personal information of more than 50,000 California residents annually. D, company derives 50% of its annual revenue by selling personal information of California residents. Or E, any one of the above. And I will let you guys answer that polling question. The struggle, of course, with California is it's a big market, and some people may know for sure that they're doing business there. And it's actually easier than people think to meet some of those threshold requirements. But I think some of the business folks that you deal with may assume, well, we don't have an office there. We don't have the location there. We're not regularly doing business in California. So that law doesn't apply to me. All right, so I think we've got most of our answers in. And I think most of you got it right. And the answer is E. It's any one of the above. So any one of those things could mean that you are subject to the laws in California. Little bit different with the new law in California in terms of the number of the number of California residents and data that you're collecting. It's the 100,000 under CPRA. All right, next slide. So bottom line, and it looks like many participants here today are subject to California or think they might be. California's law is obviously been around for a while, but it's evolving. It's only been implemented in terms of rules that the Attorney General has put in place for the last several months. It was effective January 1, 2020, but it wasn't implemented through Attorney General rules until even just this summer and year. So as we see, any one of these things could make you subject to California law. And as we'll talk in a minute, not only CCPA, but the new California law, CPRA. Next slide. All right, so I think generally people understand that California is one of the first states to talk about and protect personal information and broadly define that. And what the rules to be implemented, everybody was waiting for a little bit more clarity, a little bit more definition, and maybe some qualification as to what's personal information. But that was not changed. So it is pretty broad and similar to Virginia and some of the things that Kevin talked about. You know, there's the standard, most sensitive things like Social Security numbers, but also additional types of things like unique personal identifiers and online tracking. As Kevin suggested, Virginia is certainly true in California. The more precisely you can identify a household or individuals, the more that's going to be personal information. And frankly, as you'll see, data analytics generally is becoming PII and is subject to these laws. CCPA, essentially the goal was to give more control by consumers, initially passed against big data companies, some of the social media giants, of course, but it's evolved from that. And it means companies of all size meeting any of those criteria must be subject to it. And of course, the sale of personal information, allowing consumers to opt out in a straightforward manner to whether their data was sold, and specific opt-in requirements for consumers, you know, kids, people under 16 with parental consent. Okay, next slide. All right, so some of the rule changes that we've seen over the last several months have changed some of the definitions. So service providers and the whole, and I think Kevin suggested this in Virginia too, the notion of sale initially could be interpreted as, well, I'm not selling data to someone. I'm not a data warehouse or gathering it and selling it in the traditional sense, so I'm not subject to it. But that's evolved quite a bit. And the transfer of information, and this is going to be true even more in a CPRA, the law in California, means you need to carefully assess what you're doing with the sharing, the transfer of information. Some of the same exceptions that Kevin identified in Virginia may apply, but it's not simply, did we get money for providing someone PII or data? Personal information, as I mentioned, no further clarification. So it's very broad. It includes a lot of things, including analytics. Opt-out was heavily considered, and people were waiting for some more clarity as to what you need to do. There's now an opt-out icon, which you can see on your screen, but that does not replace the do not sell my information. So you want to make sure that if you're subject to California, you have that link. You can also include the icon that I have there. And it has to be a pretty straightforward process to be able to allow consumers to exercise that right, and to be able to tell you, do not sell or share my information. An interesting part of this is user-enabled control, and I think there'll be even more legislation, maybe even litigation over this. And that's some of the plugins. And the law talks about businesses shall treat user-enabled global privacy controls, such as browser plugins or privacy settings, data settings, as an opt-out. So very easy if someone goes to the link in your section of do not sell and exercises that, clicks on the icon or goes through the process. But may be more complicated if they do it through some of these plugins. Now, some folks think that that's going to make it easier because that will essentially be built into the system. That's another thing that companies have to pay attention to. Next slide. All right, another feature and rule change as part of CCPA is opt-out, and the notion of offline collection. So if you're gathering data or PII in paper form, whatever may be, something more traditional, then you need an opt-out that matches that, and how they can exercise that right. I mean, everything is really leaning towards digital, but you may have a company may have, whether it's through invoices or something else, a PII and data collection through that process. You need to allow opt-out in a consistent manner. And as I mentioned in the opt-out, so there's more prohibitions and specific banning of ways to make it more complicated. Companies responded to this law, but of course, a lot of folks are better if people are not clicking on this, or they can get data. So using confusing language, bearing that do not sell in something else, requiring consumers to click through or to be kind of promoted not to do it. And a third is requiring consumers to sort of scroll through privacy policies or similar documents. This is an important one. So if you bury it in the middle of your privacy policy somewhere, and it's not separate, that could be a problem. And this is why I think, again, Kevin was suggesting that traditional privacy policies have had a California section, and maybe even a link where people could go and specifically look to and exercise that right. And the do not sell, again, you can't make this hard. Businesses can require an authorized agent to do it on someone's behalf. We've seen this case where a collective set of consumers have paid organizations as their agents to go through and kind of wipe their information or exercise that right. That's fine, but they have to be authorized. And the outward facing stuff, the privacy policy, is the easy stuff. It's the technical back end to make sure that these things work that make it a little bit more complicated, and you have to build it into your infrastructure. Next slide. All right. Another big element of what is happening with CCPA is enforcement. That really got going July 1st of 2020, but it's really been heavy more recently. And these are the types of things you see on your screen here that the California AG's office has been going after. Some of the things I've already, excuse me, mentioned: inadequate disclosures. The sale of personal information section was buried or hard to follow. There were links or other consents associated with it. And again, whether it's mobile device settings or opt-out tools, just weren't effective and conspicuous. It's a little bit like the old form contracts where if it's a limitation of liability, all caps bold, you need to make this accessible to lay consumers. And privacy request responses. So companies just simply didn't follow up in time and or did not allow people to process out or allow authorized agents. So these are the things that I think California will be continuing to look at. They've got more money and resources to do that, so enforcement will be continuing. Next slide. And just when you thought it was safe to go to California, do business in California, passed by referendum is the California Privacy Rights Act, which will become effective January 1st, 2023, with new regulations introduced July 1, 2022. I'll hit the highlights of this, but it's something to pay attention to as it gets rolled out, and there'll be, again, like CCPA, a lot of rulemaking in this area. A new class of sensitive personal information, very similar to what Kevin mentioned in Virginia, needs to be considered. And new consumer rights. So again, empowering the consumer even more to correct, to get rid of, and the right to restrict the uses of some of its personal information. And that, again, in theory, rights of consumers is great. The problem is it's a burden and expense for companies to be able to process the different types of requests, whether it's limiting or completely deleting the information that they have. It also expands the private right of action. And I think, again, there will be more litigation in California because of this. Next slide. All right, I talked about the sale of information. Now sharing is a defined term, and you can see it referenced there. And the biggest impact here, I think, is on sort of behavioral advertising. The traditional data analytics and targeting that we used to do. As a default, and this is becoming true under GDPR as well, data analytics about consumers is PII. So that is a new angle of this that needs to be protected. Again, if it's in an aggregated sense, completely anonymized, you may be safe, but it is not simply okay just because it doesn't have a specific consumer's social security number, for instance. The opt-out is extended, again, to behavioral advertising, and some of the other measures are strengthened for children's data. It also removed the 30-day cure period, which was a nice thing for companies to be able to respond to issues, complaints, and resolve it. And that's now gone. And again, data limits, introducing a necessity-based data retention. So just like Virginia and just like you've done, probably looking at other states in compliance, why do you have the data you have? Should you maintain it? Especially protected or sensitive information kept in a separate place? Have you limited the number of people who have access to it? Next slide. All right, our next polling question. How current are your business vendor agreements affecting data rights? A, revised in the last 6 months. B, revised in the last year. C, work in progress. D, not since the dot matrix printer died. And I'll let those answers come in. Looks like your answers are still coming in, lots of B's and C's, which is not surprising. This is a work in progress. Revised in the last year is not bad. As Kevin suggested for Virginia, and this is particularly true for California and GDPR, these are things you're going to need to pay attention to. And next slide, please. So, and I'm going to move a little quickly as I know we're getting close on time. Contractors and contracting requirements, your service providers, your contractors, the processors, controllers. Much more important that specific provisions are included and implemented to protect yourself. And this is going to be important under CPRA, and updating privacy policy. So as you do that, Generally, you're going to look to California with ensuring that you have those consumer rights and opt-out provisions. All right, next slide. All right, great. And with that, I will turn it back over to Kevin for GDPR.
Thanks, Rob. And as Rob suggested, I know we're tight on time. You want to give you a chance to answer a couple of questions. So I'm just going to go quickly through these slides and talk about two sort of major developments over the past, actually 6 months or so, or less, with regard to GDPR. And one is the new standard contractual clauses, and then two, the continuing impact of Schrems II on US-EU data transfer from the EU to the US. Next slide, please. So there are new SCCs that were adopted back in June after a lengthy process. They went into effect June 27th, and you could no longer use the old SCCs until after September 27th, but you could continue you couldn't use the old you can't use the old SCCs any longer, but if they're already in place, you can continue them in place, but you have to adopt the new SCCs by December 27th, 2022. And it added a bunch of, it added several types of processes or relationships between controller and processes and transfers across borders. And then it has more of a modular approach now. So if you've got a controller to a controller transfer, you've got modules that you can use. If it's a controller to processor, which is more standard. If you got a processor to another processor, processor to controller, and you can go in and you can just sort of see what the provisions are and what you need to do. And it's like the old SCCs, you have to sort of abide by those terms primarily, but it does give you some flexibility to use it for the new way that data is being shared. And so it goes a lot further than the old SCCs. And then it also allows for multiple parties to sign, which is, given how the ecosystem is working, is important. Next slide, please. So the cross-border data transfers, part of this is it allows for additional safeguards, providing that you don't alter you have general responsibilities as a data exporter to your data subjects. That means you need to let them know where the data is being processed, who's being standard to get a copy of the standard contractual clauses. And you can provide additional safeguards if you're an exporter in a cross-border transfer, but you can't alter their fundamental rights. So that's an important component as well. And then data subjects have greater rights to get beneficiaries of this agreement. Next slide, please. So then on cross-border transfers for Schrems II, there was some guidance that came out, and basically it's a risk-based approach that allows you to sort of see what are the risks associated with a cross-border transfer and how do you allocate that risk between the exporter and the importer, and also an assessment of the importer's laws to make sure that you can comply with the SCCs and the fundamental nature of the GDPR. And then there are ongoing discussions regarding replacing Privacy Shield as well between the EU and the United States. Next slide, please. So Rob, I suggest that we maybe skip these takeaways because I think we've talked about most of them already. We go right to the polling question, and then we have maybe time for one question. Does that make sense?
Yeah, I think that's right. I mean, here, and I don't know if these slides are going to be available, or the things we've talked about today that are the key issues. Yeah, I agree.
Okay. So let's go to the next slide, please. So how much do you expect data protection, cybersecurity laws and regulations to impact your business operations in the next 3 years? About the same as today, A, B, a little bit more regulation, but nothing you can't handle, or C, a great deal will become a major consideration from a business and legal standpoint. Seeing a number of B's and C's. So I think that's sort of the prevailing sense from this discussion as well, certainly from our standpoint. Rob, I'm going to open up the Q&As. There's a couple on there. I'll just answer one, and then maybe you can answer one, and then we can finish
Sure.
up. How does that sound? And
That's great.
so are there a number of customers that a company may have driven by how many visit your website or actual customers? The number is going to be driven about how much personal information you collect, whether they're a customer or prospect, someone visits your website. So it's more driven by that than if they're actually a customer per se. And if I use the term customer in the discussions, I apologize, but it's more a sense of anyone that resident of Virginia that you're collecting personal information on in a consumer context or a non-employee context. Rob, do you have a question?
Yeah, so there was one earlier in the chat about a data incident and a forensic firm that outside counsel hired. There's now a request from the regulator. Do we need to turn it over? And that's pretty specific. I think it's based on the circumstances. Of course, the threshold is claim privilege and try to protect it if you can. I think that part of the presentation suggested that you need to document compliance and audit and do the things you're supposed to do, but now you need to be thinking about what parts of those would be privileged, how long you maintain them, things of that nature. So that's a tricky new part of compliance efforts for sure.
Thanks, Rob. So because we're a little bit rushed at the end, I would encourage you, if you do have questions that either weren't answered or that you didn't have a chance to ask, we have a break coming up. If you wanted to ask some questions, feel free to put them in the Q&A, and we will try to get back to everyone who had a question, directly with them if we weren't able to address it here. So we'll try to do that. I think, thank you for joining us. I believe we're heading into a break, and after this break, you're going to hear from David Burton and Amanda Weaver on the changing landscape of employment law. And I believe that starts at 11 o'clock. So once again, thank you for participating, and hope you found this useful.